Can I get a one in the chat, please? Let me know if you can hear me and we'll get this thing going. This is a quick one, as quick as I can. We have a couple of filings. Well, one filing and an order from the judge. And we're going to talk about it all. I'm going to read the documents. I do have another live schedule for this evening. Please go ahead and notify yourself for that one and hit the thumbs up on that and let YouTube know you fucks with me. Appreciate you. I can't get started, y'all, until I know if you can hear me. So let me know, please. Give me a one in the chat if you don't mind. Because I needs to go. Hello, hello. All right. I don't want to start if y'all can't hear me because I've done that before. It's not fun. It's not cool. It's not okay. Can I get a one in the chat, please? Let me know if you can hear me. I will not bother you after that. I promise. I got some reading to do. Let's go. Do I need to make a phone call or two? Thank you so much, Miss Michelle. Thank you so much. Somebody's listening. All right. So, like I said, there's a couple things with the court filings and the court and the judge decisions and whatnot. And we're going to go ahead and get right into it. See, I have the document behind here. I don't know if y'all rather see the document. I'll leave the document up. That's fine. So we're going to go with the gag order decision first from the judge. We'll let that die out on its own. So this is from Judge Aaron Subramanian, United States District Judge, United States versus Sean Combs. On October 20th, 2024, defendant Sean Combs moved for an order prohibiting prospective witnesses and their attorneys from making extrajudicial statements that he argues will substantially interfere with his rights to a fair trial. In terms of those who those quote and end quote prospective witnesses are, Combs clarified that the category includes, in quotes, all those who claim to be victims. The government opposed this victim gag order as extraordinary and beyond purview. For the reasons below, the motion is denied. Combs authorities don't support a gag order applicable not only to trial participants, but also to any alleged victim and their lawyer. Doesn't authorize this kind of relief. Local Rule 23.1 doesn't authorize this kind of relief. The limitations of that rule don't even apply to witnesses, let alone prospective ones that haven't yet been identified. They certainly don't apply broadly to any alleged victims and their lawyers. Even Local Rule 23.1H, which allows the court to issue special orders related to extrajudicial statements, only applies to parties and witnesses. And to impose a special order, the court must consider whether it will be necessary to ensure an impartial jury and must find that other, less extreme available remedies, singly or collectively, are not feasible or would not effectively mitigate the pretrial publicity and bring about a fair trial. Among other remedies that the court is required to consider are a searching voir dire, emphatic jury instructions, and sequestration. I can't say it. Sequestration. Basically, sequestering of the jury, which they did in the R. Kelly case. Matters that Combs hasn't addressed. So basically, the judge is saying you guys skipped a whole bunch of other options we could have explored before going to a gag order. And they listed some case law here: United States versus Gotti, 2004. Combs' Sixth Amendment authorities don't support his proposed order either. And then they want to talk about in Shepard versus Maxwell, 384. The Supreme Court observed that the trial court might well have prescribed extrajudicial, I cannot say that, statements by any lawyer, party, witness, or court official, which divulge prejudicial matters. But it did not indicate that blanket restrictions on potential witnesses, or even more broadly, all alleged victims, would be appropriate. So more case law cited. I got to skip through because my time is limited to y'all. So basically, this thing is denied. The judge is telling them why, basically saying, this is not something we do. We don't just skip straight to a gag order when we could have maybe question the jury or include things in the voir dire that will eliminate such things from happening that you're trying to prevent. So the only decision Combs identifies that appears to involve a bar on speech by all potential witnesses is United States versus Brown. In that case, the district court imposed a gag order prohibiting parties, lawyers, and potential witnesses from making extrajudicial statements. While the Fifth Circuit upheld this order, it described the order as only affecting attorneys, parties, and witnesses, and its discussion of the constitutional considerations at stake characterized the order as a restriction on the extrajudicial speech of all trial participants. So, yeah, judges have to be careful, when they grant such things, basically creating precedent for cases to follow, opening a door for is basically suppressing people's um, rights to free speech, in my opinion. I'm no lawyer. Okay. So let me just go through it real quick to see if there's anything. Yeah. So let me just read a little bit. Not all alleged victims will be participants in this case, and a blanket restriction on their speech will silence individuals who may never have anything to do with the proceedings here. And in any event, less restrictive alternatives must be considered and rejected before imposing a restraint on speech. Okay. I'm going to read this last paragraph. Balancing the interests at stake, the court has already taken steps to limit what can be said publicly, including issuing an order underscoring the requirements of FedR Crime P6E and Local Rule 23.1, and further requiring the government to make those requirements clear to anyone involved in this case. As the court stated in that order, it will take appropriate action for violations of the rules or this court's order. The court is open to other tailored proposals that will help ensure a fair trial. As to the as to the mounting civil cases against Combs, there are further steps that he can take. He is in italics, like stressing he can take, including seeking relief in particular cases if the parties or their lawyers have made prejudicial statements to the press, or moving to stay those cases pending the resolution of this one. Just to give two examples, however, the unprecedented relief that Combs seeks in this motion is unwarranted. Wow. So the judge offered him a couple of solutions in order to how to deal with those civil cases that are piling up on him. Told him, you can file for a stay and basically put them on pause until we get finish this, or you can also basically respond to them. Let's see. Yeah. So seeking relief in particular cases, if the parties or their lawyers, there are steps. So you can stay those cases pending resolution. Yeah, seeking relief. So seeking relief in particular cases, you can probably file some things against them if you feel they're overstepping or overreaching in the press. But don't come to this case, this criminal indictment, and try to put stuff in this and trying to affect the people in the civil cases. They're like, you need to deal with those civil cases directly. So anyway, yeah. So that was that. On that, the judge just basically denied the gag order. The judge did say that he's open to other resolutions if that are tailored differently. Basically saying, you missed the mark on this one, but you could try it again if you want. That's what I got from that, at least. All right, so I want to move over to his latest bail request, because mind you, this judge came in right after he was denied the second bail request, and he was going to take it to the district judge, but sorry, the higher court, the Second Circuit, but then decided instead the government came through with something that was sealed to say, hold up on this 3-panel judge situation for this third bail request, Second Circuit, because we have something that we need to present, or we need the judge to see something first. So when that happened, then Diddy, his attorney, said, oh, well, hold up, let's just pause let's put a pause on this because we also have some new evidence. And we also have some stuff that can allow us to go back to the district judge to apply for the third request. So basically, they don't want to blow this higher request if they don't have to use it yet. It's like using a card you don't have to use just yet. So here is, let's go through the bail request that he filed and see what exactly do you have. What do you have that's new and different from the first time you filed and the second time you filed? So this was 5. All right, I went through all the contents, the table of contents and all that. Mr. Sean Combs, let me turn this down. We don't need no background. Okay. Mr. Sean Combs, through his counsel, renews his motion for release pending trial. This renewed motion is based on a significantly updated proposal bail package, new evidence, as well as changed circumstances regarding Mr. Combs' ability to prepare for trial while detained. First, Mr. Combs proposes an updated bail package that is far more robust than the previous proposal, as well as other bail packages routinely approved by the courts in this circuit. The proposed bail package even surpasses a bail package recently requested by the government in a comparable case in a neighboring district. And I think they're talking about that CEO of the Abercrombie and Finch, who got out, I believe, on a $10 million bail like the same dang day. So this goes on to say the updated proposed conditions, which include home detention with a strict 24/7 security monitoring arrangement and near total restrictions on Mr. Combs' ability to contact individuals other than counsel, will reasonably assure the appearance of Mr. Combs as required and the safety of any other person and the community. Second, new evidence received in discovery from the government undermines the primary basis on which the government initially sought and Judge Carter ordered detention. Okay, so what's this new evidence? The evidence makes clear that the government's case is thin. How can they even say that when they don't even have all the evidence? The government made clear they have tons of evidence that they're still working through, file tagging and bagging so they could get it to them. Anyway, let me continue on, child. It confirms the defense's initial description of the events depicted in the March 16th video recording. The video is not evidence of a coerced freak-off, but rather a minutes-long glimpse into a complex but decade-long consensual relationship between Mr. Combs and victim 1. Okay, so they're talking about the Cassie tape in the hotel hallway where he's beating the crap out of her like she's not even a living human being, like she's just a rag doll, saying that this is not evidence of any coerced freak off, basically saying that's all other than this. This is all y'all got is freak off stuff. This is actually something between a couple who've been together for a long time, a decade, and they had a complex relationship. And so what he's saying, it's a minutes long glimpse into something that we had no idea that this stuff was going on in this relationship. To me, this is actually damning, saying that what you saw, this is what they do. This is normal for them, which it's criminal. On the level that he was abusing or hurting her, it was criminal. I don't care if it was consensual or not. We know it wasn't consensual, okay? The girl was running and sneaking off, trying to get out of there. But this is crazy. But anyway, let me keep reading. Additionally, the new evidence refutes the government's proffer at the initial hearing regarding a potential second alleged victim. And the new evidence confirms that the government's obstruction and witness tampering allegations at the initial bail hearings lacked a factual basis. Third, Mr. Combs' current conditions of confinement infringe his constitutional rights to participate in his defense. So they're talking about the fact that he's locked up and the conditions under which he's locked up prevents him from even being able to fight his case. But you guys have already decided based on the evidence, there is no case. So then, but as they say, given the government's amended estimate of the amount of discovery in this case and its unique format, including voluminous video and photographic evidence, Mr. Combs' release on the proposed conditions is necessary so he can review the discovery and prepare for trial. Despite the MDC's best efforts to facilitate the defense's team's needs, the current arrangement makes trial preparation impossible, as evidenced by the recent multi agency sweep of the facility and resulting lockdown. The Bail Reform Act and the Constitution demand more. Boom. I knew that story about that bail sweep. That whole thing was Diddy. I told y'all. I said Diddy probably did this. Number one, I said to make sure he's not threatened by any weapons or anybody that could possibly hurt him. Two, to make sure maybe he the only one that could have a phone because he don't want nobody plotting on him, or his family making phone calls and such. And then also now, based on what they're saying here, the sweep in itself is evidence that this place is horrid and the conditions are disgusting and terrible. So it could have also been to stage a situation of look, something they could hang their hat on, something they could say, look, they came in, an interagency sweep went through this jail because it's so horrible. Like, so in itself, it could have been just for that reason, just to give me something to put in my bail request. Like, how do we prove this place is just that bad? Because the talk has been around and the evidence of it actually for a long time, for years. This is a notorious jail. It's the only federal jail in New York. So you got all kinds in there, right? But now all of a sudden, since Diddy's in there, they have a multi-agency right before he files for a third bail request. Okay. Accordingly, Mr. Combs moves to reopen the prior detention decision and request release on the proposed updated conditions detailed herein. And of course, the government is going to respond to this. But number one, the court's authority. The court can revisit prior detention order under two separate provisions of the Bail Reform Act, 18 U.S.C. 3142 F and 18 U.S.C. 3142 I. Section 3142 F permits a new bail hearing at any time before trial if the judicial officer finds the information exists that was not known to the movant at the time of the hearing, and that has a material bearing to the issue whether there are conditions of release that will reasonably assure the appearance of such person as required, as required, and the safety of any other person and the community. 3142I expressly permits this court to revisit a detention order and to release a defendant in custody to the extent that the judicial officer determines such release to be necessary for preparation of the person's defense or for another compelling reason. Moreover, the court has inherent authority to reopen the hearing even when the circumstances do not match 3142F statutory text. And they state a case, United States versus Maxwell. Whereas as here, the case has been reassigned, the court is not bound by prior rulings and should review the record de novo, United States versus English. Okay, so they are just basically letting the court know you have the authority to do this. Already precedented. Okay, number two, the proposed updated conditions of release are sufficient. The defense proposes the following updated bail package, which will assuage any concerns of danger and obstruction and will ensure Mr. Combs' appearance in court. Here we go. Number one, a $50 million bond. A, co-signed by Mr. Combs, his mother, his sister, the mother of his oldest, the mother of his youngest daughter, and his 3 adult sons. So they added more people onto who else was going to sign, because last time I think it was just his mother, the oldest daughter, Chance, I believe, maybe her mother. B, secured by in Mr. Combs' residence located in Miami, Florida, an unencumbered property appraised at about $48 million. Okay, so they've added a property or an amount. I guess they put in the house up. Equity in the house in Miami. 48 mil. Okay. Further secured by the equity of Mr. Combs' mother's home in Miami, Florida. And I think weren't those already in place from the first bond? Maybe the second one was added. Okay, so number two, full home detention at his residence in Miami or at a suitable location in New York with GPS monitoring. Have y'all seen that Miami mansion, honey? Are they talking about the one on Star Island? A whole country in itself where he could just roam is like he's on a private island. Okay, A, council will travel to this location for any in-person meetings with Mr. Combs or have council meetings via video. B, to the extent Mr. Combs' travel is necessary, and in parentheses it says to attend court or pre-approved medical appointments, his travel will be restricted to the southern and eastern districts of New York and southern district of Florida. So they're saying he needs to be able to go back and forth to different parts of New York and then back to Florida. But he won't go anywhere else, we promise. C, Mr. Combs will pay all or part of the cost of location monitoring. So, and y'all don't even have to worry about these taxpayers' money because he's going to come out of his own pocket. Number 3, 24/7 monitoring by qualified security personnel approved by the government and pretrial services. That's nothing new. Number 4, Mr. Combs will have no access to telephones or internet except for during calls with counsel to be arranged by security personnel. That was also previous in the previous request. Number 5, restrict all visitors except for counsel and pre-approved list only consisting of specific family members with the consent of pretrial services and the government. A, family visits will be scheduled only with pretrial services prior approval. B, security personnel will monitor family visits. Number 6, Mr. Combs shall avoid all contact directly or indirectly with any person who is or may be a victim or witness in the investigation or prosecution. Number 7, Mr. Combs will consent to provide pretrial services, random access to the residence. Number 8, so random checks. They're saying number 8, Mr. Combs' passport was surrendered to his counsel on April 1st, 2024, which counsel will provide 2 pretrial services. This is 8A. The following family members have also already surrendered their passports to counsel, who will provide them to pretrial services. I, Janice Combs. 1, Janice Combs. 2, Chance Combs. 3, Jesse Combs. And 4, Delilah Combs. And I'm curious as to why just the girls, why not all the children? Maybe just because they're minors. Because I don't see the baby on here either. Okay, council will continue efforts to sell Mr. Combs' airplane. So remember, I think he had 2 planes, and he was able to sell one, but the black one he still has. There was an all-black jet. Number 10, the defendant shall submit to testing for a prohibited substance if required by the pretrial services office or supervising officer. Testing may be used with random frequency and may include urine testing, the wearing of a sweat patch, a remote alcohol testing system, and or any form of prohibited substance screening or testing. The defendant must not attempt or tamper with the efficiency and accuracy of prohibited substance screening or testing. So basically, they're just saying he's going to, be available for random drug tests, scheduled drug tests, random drug tests, and that he promises not to tamper with the results or tamper with the tests themselves to manipulate the results. Number 12. Number 11. Mr. Combs must participate in a program or counseling if directed by the pretrial services office or supervising officer. Number 12, all other standard conditions of pretrial release. So I didn't really see much different except for maybe the second property, maybe adding some more names onto who's given up their passport. No, they added names. Onto a part. I'm trying to find it. Oh, okay. The co-signing of the bond. Okay, so the footnote, the first footnote on page 3, on October 24, 2024, the Second Circuit granted Mr. Combs' motion to hold his bail appeal in abeyance pending decision on the instant motion. Thus, the appeal does not foreclose the relief requested here. Okay. Additionally, for the avoidance of any doubt, and as stated during the September 18, 2024 hearing, so basically we're copying and pasting from the last request, in quotes, if your honor wants something more or different, we can do whatever your honor thinks is necessary regarding the release conditions. These proposed conditions present an extremely substantial comprehensive bail package for and are plainly sufficient to warrant pretrial release under 18 U.S.C. 3142. For example, the Second Circuit affirmed the release on similar but far less restrictive conditions of a defendant charged in multiple counts, including drug trafficking, firearms, ex trafficking, and related offenses in United States versus Fox. And Fox is just one of many cases concluding that such conditions are adequate. So they're like, look, it's worse guys out there than him that got bail. Okay. So they're going to list some other cases, some precedents of people getting out that had similar reasons of why, he can't get out. Let's see. Indeed, the government recently successfully requested pretrial release for two similarly situated defendants, including a CEO accused of ex-trafficking dozens of young men, including through witness intimidation. See United States versus Jeffries, and that's the Abercrombie and Fitch guy. In Jeffries, the government sought release despite claiming the defendants relied on the services of a security company to surveil and intimidate witnesses, thereby securing their silence. Oh, so they're saying this man was accused of threatening people using security at that, but they gave him bail anyway. The conditions, number 3, the conditions of release requested in Jeffries pale in comparison to the conditions proposed by Mr. Combs here. There, the government requested bonds of $10 million and $500,000 respectively, defendants, and release home detention with GPS monitoring. The requested conditions included no additional security on surveillance arrangement whatsoever. The conditions proposed here are more restrictive than in most of the other cases cited above. Mr. Combs would be in the custody of professional private security officers, whereas most of the cited cases imposed only electronic monitoring or placing the defendant in custody of a relative alone. The proposed security monitoring is precisely the situation contemplated by the statute. It specifies that conditions may include the defendant remaining in the custody of a designated person who is able reasonably to assure the judicial officer that the person will appear as required and will not pose a danger to the safety of any other person or community. As Judge Rakoff has explained, if a defendant is strictly confined to an apartment with electronic monitoring, there is no meaningful likelihood he will engage in any conduct constituting danger or tamper with the witnesses. But he's not living in no little apartment. Anyway, moreover, because they could totally swap him out for somebody with his same build and skin tone and have them walking around his mansion in pajamas all day. Anyway, moreover, although the court should make its own determination, de novo, see English 629, blah, blah, blah. The updated bail package proposal mitigates the specific concerns that Judge Carter identified during the initial September 18th detention hearing. During the hearing, Judge Carter's primary concern appeared to be a risk that Mr. Combs could obstruct justice and intimidate witnesses using third parties, specifically to be that he would still have access to employees and other individuals and could obstruct justice and intimidate witnesses through those folks, through even coded messages if necessary. However, under the proposed updated bail conditions, Mr. Combs would not have access to employees and friends and the like, and would not speak with these employees. So are they saying that they want to isolate him completely aside from security and his attorneys coming in and out, and then of course with approved visits from his family, and that's it? in that big old mansion. Okay. Uh, Section 3, the Section 3142G factors favor release in light of new evidence. Reviewing the 18 USC 3142G factors de novo in light of the new evidence demonstrates that detention is not warranted. A. The nature of and circumstances of the offense charge. The indictment has three counts: racketeering conspiracy, ex trafficking by force, fraud, or coercion, and three, transportation to engage in prostitution. The racketeering conspiracy count does not allege that Mr. Combs himself engaged in or conspired to commit any particular racketeering act, and the grand jury did not need to find probable cause regarding such conduct to return a true bill. This is because 18 USC 1962D does not require proof of the commission of any racketeering act or any overt act. And they're citing more case law. Nor does the defendant agree to commit or facilitate each and every part of the substantive offense, or even the two predicate acts of the alleged conspiratorial agreement. For the purposes of the bail, then, there has been no affirmative grand jury finding that Mr. Combs committed or conspired to commit any of the acts set forth within in the pattern of racketeering activity, included in the paragraph in the indictment, 13A through H. So they're saying he didn't even do it. They didn't prove he did that. They just saying he was a part of the conspiracy. Count 2 alleges that Mr. Combs committed the crime of sex trafficking starting in 2009 and concluding 6 years ago in 2018 against a single victim, victim 1. The indictment contains no allegation of additional victims or minor victims. There is also no allegation that any sex trafficking occurred in the last 6 years, although count 2 triggers Section 3142E 3D's presumption of detention. It is only charge that does so. It is the only charge that does so. Of course, even in a presumption case, the government retains the ultimate burden of persuasion by clear and convincing evidence, citing case law. Letter B, the weight of the evidence in light of new evidence. Over the past 6 weeks, the defense has received approximately 23.5 terabytes of discovery material. The material reveals new information about the case, the evidence, and the government's previous bail contentions that was not known to the movement at the time of the hearing. The new material demonstrates that the government previously misrepresented the weight of the evidence, and it undermines the government's claim that Mr. Combs presents danger. First, the discovery includes, and it's redacted out, so we don't know what the discovery is, that refute the government's core sex trafficking allegations. Second, the new discovery negates the government's claim at the initial detention hearing that there is a potential second victim. Third, the discovery shows the government's obstruction and witness tampering allegations were entirely misleading. And finally, the government failed to disclose the court information regarding blank testimony that undermines its claims. We take each in turn. Letter I, communication with blank, redacted out, corroborate the defense. As noted, and I think that's Kalena from Dirty Money. Remember when we played that interview she did, and she seemed high out of her mind. But I think they're referring to her. As noted, the government's allegations of ex trafficking relate to one woman, referred to the indictment as alleged to victim 1, with whom Mr. Combs shared an 11-year relationship. Okay, never mind on that, because that was not referring to her. Okay, so it says that included in the discovery materials are, and it's all redacted. It's all redacted. The first mention of any extra or unwanted sexual contact involving alleged victim 1 was in November 2023. And we know victim 1 to be Cassie Ventura, right? 5 years after the couple's 2018 breakup. The evidence shows that the allegations were merely attempts to obtain a financial windfall from Mr. Combs. In the spring of 2023, victim 1 revealed to one or more others that she needed money to support her small family. Oh, really? She told others that she had started writing a book about her relationship with Mr. Combs. In June of 2023, she texted Mr. Combs' employee that Mr. Combs should contact his lawyer to have his lawyer speak with her lawyer. She followed up on this by text on June 15th. The same day, her lawyer contacted one of Mr. Combs' lawyers who was expecting that she might make an extortionate demand, recorded the conversation. During the approximately 8-minute recorded call, the lawyer confirmed victim one was writing a tell-all type book and that Mr. Combs could buy the exclusive rights of the book for $30 million, which would ensure that it was not published. Mr. Combs and his lawyers considered this an extortionate demand and did not pay the money. And I know he regrets it to this day. In the fall of 2023, Victim One pursued a different strategy. The Adult Survivors Act, ASA, which suspended the traditional statute of limitations for S assault claims, was scheduled to expire on November 24, 2023. In November, Victim One indicated in discussions between her lawyer and Mr. Combs' lawyer for the very first time, 5 years after their relationship ended, that she had been abused by Mr. Combs, again demanding $30 million. To be clear, the statute of limitations for non-sexual assault, battery, and other alleged offenses were subject to the typical statute of limitations for those torts. Accordingly, the only way a plaintiff could avail herself of the ASA is by alleging S assault. Thus, on November 16, 2023, days before the ASA expired, Victim One filed a civil complaint alleging inter alia ex trafficking. The case settled quickly without any admission of wrongdoing. With the release of the civil complaint, the law enforcement saw an opportunity to build a criminal case against Mr. Combs. Discovery shows within days of the civil case settling, this investigation began. The government recycled Victim One's allegations, but the case requires her potential testimony, which will be refuted by years of written correspondence and other documentary evidence. So they're like, look, you really only have Cassie. We have a lot of stuff to show that what she's saying is not necessarily true. And even though you saw her getting her ass whooped on that videotape in the hotel, that was just what they do. That was their normal, complex relationship behaviors. Number 2, the alleged second victim is not a victim at all. During the initial bail hearing, the government alluded to a potential second victim, arguing that Mr. Combs' contact with this purported victim were evidence of obstruction. September 18, 2024, however, and then this is redacted out. Then it says, despite the government's claim, blank, that this woman is a ex-trafficking victim, the defense has learned that the government has not even spoken to her, nor was she the target of any obstructive conduct by Mr. Combs. The government clearly misled the court and concealed the true facts during the initial bail hearing. For example, the government knew blank, 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 blank. The government also knew, and they redacted some stuff. But the government was nothing of the sort, which the government clearly knew. Indeed, the discovery confirms blank. A lot of redactions. Number 3, the government's other obstruction and witness tampering allegations were false. Now, I don't know who was the second person they are saying was like a tease and not true, that they haven't even talked to yet. I don't remember who that was. I'm gonna have to go back to the indictment. That says the discovery also undermines the government's argument that Mr. Combs attempted to tamper with other individuals, including grand jury witnesses. During the previous bail hearing, the government outlined what it billed as obstructive communications with grand jury witnesses in June and July of 2024. September 18, 2024, it further characterized Mr. Combs' September 2024 communications with another person as witness tampering. Oh, that might be Kalina from Dirty Money, who got like 50-something phone calls or whatever. Judge Carter considered this the government's most persuasive evidence, posing the questions to the defense. If he's aware of this April 1st, 2024, then again, why is he contacting witnesses in June and July of 2024? What would be the purpose of Mr. Combs continuing to speak to that witness after September 11th? But the recent discovery now corroborates the defense arguments at the initial bail hearing. At the hearing, Mr. Combs' counsel explained that his contacts with these people were not in any way obstructive. One grand jury witness contacted him, not the other way around. What? A grand jury witness contacted him? Or who? Okay. The September 2024 communications were with an individual represented by counsel who wanted to make a publicist statement. And to the extent individuals were contacted, defense counsel that to conduct a responsible defense investigation, it must, of course, continue to interview witnesses. In opposing these arguments, the government misled the court and concealed the actual content of the communication. The truth, however, is that a grand jury witness, the one with whom Mr. Combs had not spoken to in several years, and that's in quotes, and now this part is redacted, these statements, which the government conveniently withheld from the court, in no way evidence obstruction. The same is true of the individual with whom Mr. Combs contacted in September of 2024. So a grand jury member was calling him, and supposedly they hadn't spoken to each other in a long time or whatnot, and it was held back. The conversation, the communication was held from the court. Well, hell, if he had contact with the person, wouldn't he have been able to say that this is what happened? Like they're acting like, oh, we just found out when we saw all this evidence and we saw the communications. Well, he should have told you. Well, they contacted me. I didn't contact them. And then they could have did their due diligence, their research or whatever. That just sounds weird. If somebody's contacting him from the grand jury, what else are they sharing? What did they share with him? Like, they're not supposed to be contacting anybody. It says, but during its proffer to the court, the government concealed these facts, which completely undermined its claim that the timing of the contacts with the person in September 24 suggests obstruction. Mr. Combs is entitled to have his counsel conduct a thorough defense investigation. Indeed, his constitutional right to the effective assistance of counsel demands it. At times, counsel might also need Mr. Combs' assistance and involvement to conduct a proper investigation. Of course, Mr. Combs has a constitutional right to participate in his defense, and if witnesses are contacted to support his defense, that alone does not amount to obstruction or evidence any risk of obstruction or danger. Testimony of blank undermines the government's case. Defense counsel noted that at the initial hearing, that based on defense interviews and investigation, several individuals associated with a male companion agency have stated to the prosecutors that they are paid for their time, not for having sex. And then we have some more redactions. This is not a surprise, as the companion agency is not some secretive underground operation. It has been operating for over a decade with a website of over 10,000 followers on X, formerly Twitter, and its operations have been featured in well-known magazines. Its CEO actively courts media attention, starred on a Showtime series about male companions, and has repeatedly interviewed on national talk shows and the national news. According to the CEO, the company's services have exploded in popularity because of all this publicity. In other words, the government's allegations are incredibly weak and contradicted by the testimony of its own witnesses and the discovery received to date. C. Mr. Combs' character and history and other section 3142G3A factors. The Bail Reform Act requires court to assess a person's character, physical and mental condition, family ties, employment, financial resources, length of residence in the community, community ties, past conduct, history relating to drug and alcohol abuse, criminal history, and record concerning appearance at court proceedings. In addition to Mr. Combs' prior arguments regarding his cooperation to date, which we incorporate herein, we note the following. Number one, Mr. Combs' character. Mr. Combs has never run from a problem. He has had more than his share of adversity. As he does now, and he has responded to every such challenge with integrity. Mr. Sean Combs was born on November 4th, 1969 at Women's Hospital in Harlem, New York. Women's Hospital, interesting. His mother, Janice Combs, was a teacher's assistant. His father, Melvin Combs, died when Sean was 3 years old. His mother and others told him that his father died in a car accident. It wasn't until years later that when Sean was a student at Howard University that he researched microfiche and learned his father was unalived. Determined to not let her only son follow in her husband's footsteps, you see how they don't mention nothing about what his father did for a living or anything about his ties. Anyway, Janice was perhaps extra protective of Sean. She raised him with a strong belief in God, religion, faith, and redemption. At the age of 10, he became an altar boy at the parish of St. Charles Borromeo in Harlem. He also spent his Sundays at the Shiloh Baptist Church, also in Harlem. When Sean was about 12, he and his mother moved to Mount Vernon, a small city in Westchester County bordering the Bronx. Sean attended and graduated from Mount St. Michael Academy, an all boys Catholic high school where he played on the football team. His ties to his community run deep. So, yeah, far he is. This guy, he's 54 years old. They're going back to his childhood to talk to you about how good of a character he has because he went to Catholic school. That might work the other way on you. Okay, number two, Mr. Combs' career and work history. While a student at Howard University in Washington, D.C., Mr. Combs began working for free at Uptown Records, which was created in 1986 by Andre Harrell to be the first major hip hop music label in the world. I don't know if it was the first, but it says Combs bunched his classes at Howard on Tuesdays through Thursdays. This sounds like something from a YouTube video I listened to recently about his life. Sounds like they just transcribed from the video. So yeah, they're talking about. I got to kind of skip to the loo here, but basically just going through all of his history as far as working from at going to school, working for Uptown, bunching his classes together so he can have the end of the week to just go back and forth, to go to the record label. What a sacrifice he made, what a hard worker he was. And he's, hard work and drive and ambition. And they said that's why he got fired in 1993. And instead of seeing this as a setback, he saw an opportunity and he created Bad Boy. Did they mention Clive Davis backing him here, the devil himself? No, I don't see Clive Davis's name. But he was 24 years old, and Combs had a vision for a new type of business, one headed by a Black executive that emphasized Black excellence and achievement. It would reflect a certain style, sound, and sensibility that was modern, hip, and urban. Before long, many of the most talented young artists were signed with Bad Boy. So how does this have to do with him getting bail? That's what I'm trying to find out. But they go on to say, in June of 1997, he wrote and sang his first hit song, I'll Be Missing You. Did they talk about why they were singing the song? Because because Notorious B.I.G., Christopher Wallace was unalived, probably at his behest. This is insane. With Faith Evans, which was a tribute to his friend. Oh, here we go. Christopher Wallace, better known as famous, talented, Notorious B.I.G., who was unalived in Los Angeles 3 months earlier. In February 1998, Combs' debut album, No Way Out, won a Grammy Award for Best Album. And that should tell you all you need to know. Once Biggie was out the way, he was able to get on stage and be nominated for a Grammy. Later that year, Combs started the clothing line business Sean John, which went on to win Council of Fashion Designers of America awards. Oh yeah, his life just blew up after that. Combs was the first Black man awarded to the CFDA Men's Designer of the Year award in 2004. 2002, he produced MTV reality show Making the Band. Do they talk about all the things that he threw that chair at Lorianne Gibson and all the other things? The contestant who was abused 3 days of the auditions aside. 5 years later, in 2007, all the stuff with Danity Kane and all the behind the scenes. See, they want to mention all this stuff, but they really open the door for us to really hear the dirty and nasty parts of this. They go on to say that he became brand ambassador to an equal share venture partner with the British I don't know if he was equal share, but anyway, multinational beverage company Diageo for the French beverage producer Ciroc. And in 2013, Combs co-founded a television network called Revolt, which carried music videos programming related to social justice. You really could say after Biggie passed away, his whole life really just blew up, and his trajectory was just straight up to the top. That's called the ultimate sacrifice. It says that, however, in the wake of the November 2023 lawsuit, he took a leave of absence from many of these ventures. So basically, this lawsuit that is really not even real and true crumbled his life, and his life is now in shambles. This brief review of Combs' work history shows that Combs responds to adversity by facing challenges directly and working even harder to overcome them. He does not run from challenges, nor does he cheat or break rules in addressing them. Instead, he takes them head on, and he has already done, as he has already done with this challenge, and he will continue to do. Contributions to the community. They go on to talk about the philanthropic endeavors that he cares about the community here in New York and elsewhere. Since founding Bad Boy Entertainment, he's actively supported and donated millions to after school programs and organizations like the Boys and Girls Club. He also supports organizations, including the National Foundation for Teaching Entrepreneurship, creating opportunities for young entrepreneurs. A cornerstone of his philanthropy is education, and he fulfilled a lifetime long dream when he was with a partner, opened Capital Preparatory Harlem Capital Charter School in 2016. And I did a whole live on that and how dysfunctional and horrid the conditions were for those kids as far as the education goes. All they cared about was how fresh those uniforms were as far as the executives. And Sean Combs never basically really showed up. Like they're trying to make it seem like he's so hands-on, and the money also wasn't there for the teachers. That's why they had so much turnover, because they weren't getting paid. Money was going somewhere, but not to the teachers and student supplies. Goes on to say the success of this initiative led to a launch of Capital Preparatory Bronx Charter School in 2020, with Combs donating $1 million to support its development. He's also been proactive in health and disaster relief efforts, having raised over $2 million for New York City public schools, hosting a virtual dance-a-thon that raised more than $4 million to provide personal protective equipment to healthcare workers in the front line of the COVID pandemic. I wonder if that's when he was doing that IG Live, having everybody twerk for him. Mr. Combs' philanthropic work has earned him numerous accolades throughout his career, including the Triumph Award from the National Action Network in 2016, the Superhero Award from Room to Read in 2017, the Child of America Award from Carver Foundation in 2018, and in 2023, the Icon Award from the Apollo. So I wonder, they didn't mention the getting the keys to the city and all these things because they got taken back. But I remember he got all these other things last year too. Another Icon Award, all kinds of stuff. Now they want to highlight his family relationships. Because the government argued that Mr. Combs is a flight risk and danger, we further addressed the brief fashion in his history of long-term relationships and family ties. Although Combs never married, he has had multiple significant long-term relationships that are relevant here. He fathered his first child, Justin, who is now 30 years old, with Misa Hilton. He was in a long-term relationship with Kim Porter. How dare they bring Kim Porter into this? Who he called the true love of his life after the tragic passing from lobar pneumonia in 2018. And you see they made sure to put that in there to disparage any rumors that he had a hand in her unaliving. With Kim Porter, he shares Quincy, who he adopted. So I want to see these adoption papers. Since you want to put it in this court, it's up for challenge. So now you're going to have to prove that he literally adopted him. And if he did, then I'll be sure has some questions to answer. Christian and twin daughters. He fathered his 18-year-old daughter, Chance Combs, with his longtime friend, Sarah Chapman. Oh, okay. But you didn't mention that they were pregnant at the same time. Okay. And they were friends too before. Anyway, Chance is now enrolled at Tisch School of Performing Arts at New York University. Finally, I wonder, and Chance is the same age as the twins, but she's a year above in school. So that says a lot about, I guess, her mothering. Finally, he has a 2-year-old daughter, Love. All that says is he's spread his seed around. They want to say, oh, he has long-term relationships. We go look up Kim Porter and see how many petitions and people are, demanding the reopening of her case because Mr. Combs probably has something to do with it. Mr. Combs also supports his 83-year-old mother, who recently underwent brain surgery. Oh, wow. And was in the hospital as recently as this summer with a heart issue. Although Mr. Combs is not his mother's only caregiver, he assists with her medical care. Sean Combs' 7 children and his mother love and support him and need his love and support. The mother of 4 of his children, Quincy, Christian, and his minor twin daughters, Kim Porter, passed away, and his children are now left with an incarcerated father. That's his fault. His minor child, now 2 years old, has not been able to see her father since he was incarcerated and misses him dearly. I thought they took her. Oh, I guess not. So they also saying number four, Mr. Combs cannot adequately prepare while detained at MDC. Incredibly voluminous discovery makes preparation from prison impossible. I doubt that they could say like R. Kelly, he had a lot of evidence, child. We saw that video, that evidence coming in on carts, and he, even though he lost, he was in prison the whole time. At the October 10, 24 status conference, the government described an unprecedented volume of electronic discovery. This includes terabytes and terabytes of data extracted from at least 96 electronic devices seized at Mr. Combs' residences in Miami, Los Angeles, and elsewhere. So you want to discredit the evidence that you have, but then you want to say, but there's so much evidence that they promised us that we need to get him out of here because otherwise we're not going to be able to have him review it. So you're really admitting that you haven't even seen most of the evidence and that it's so much of it that he can't deal with it in prison or in jail. Wow. The data extracted from other devices include yet more terabytes. Even a single terabyte of data is roughly equivalent to the information contained in the books of 12 floors on 12 floors of a typical academic library. Wow. The data here is so large that the government representative would need to engage in further dialogue with the defense as to how exactly this data could be transferred to the defense team. Those discussions those discussions continue. And that is not all. The government further described voluminous subpoena returns and Brady's disclosures and a particularly complicated privilege review process whereby the filter team will share initial batches of possibly privileged material with the defense for its own review. The government maintains that its investigation is very much continuing, caveating that more discovery is likely down the road. It further noted that it has yet to succeed in extracting and restoring certain devices, describing such processes as a work in progress, some contingent on technology advancements. These hurdles persist and have stalled the defense's review and preparation. The defense's recent attempts to confer with the government regarding Mr. Combs' use of a laptop further confirm the current conditions are not tenable. There is no way Mr. Combs can review all the discovery during visits by his attorneys. He needs a laptop so that he can work on his case as often as possible on his own time. However, even though he has been in custody since September 16th, he still does not have a laptop. Defense counsel has been working with prosecutors since Mr. Combs' arrest to supply him with a laptop that complies with MDC's security requirements. After numerous delays occasioned in part by the government's misunderstanding of the MDC's rules, counsel provided a compliant laptop to the government on October 8th, nearly a month ago. Nevertheless, as of today, Mr. Combs still has not received or been able to use any such laptop, meaning he cannot review certain files at the MDC. This includes discovery that is critical to his defense and trial preparation. Well, y'all have to bring the laptop with you. That's the whole point of being there with your client. Even if you have to be there, I'm pretty sure they have open hours. If you got to sit there with him from the time you get up and get your coffee to the time, you take a lunch break, come back. It's a job, right? And you're getting paid by the hour, I'm sure. The government has numerous case agents, endless resources at its disposal to conduct its review. Still, it estimates it will need at least until the end of the year to complete discovery. Much of the discovery also includes difficult to review evidence, such as video footage and photographs subject to heightened protections under the order. Even assuming Mr. Combs obtains a laptop, counsel is able to share critical discovery with him and visit him at the MDC every day uninterrupted. It will be impossible for Mr. Combs to review this incredible volume of evidence under the present conditions. Okay, well, then they say that the conditions specifically frustrate Mr. Combs' preparation. They go on to cite a bunch of case law, saying that the current conditions further impair his ability to prepare for. They starting with the frequent lockdowns at MDC. They say that lockdowns just persist. As many judges in the southern and eastern districts have observed, inmates at the MDC spend an inordinate time on lockdown. Mr. Combs has not been spared from these lockdowns, which have directly frustrated his defense preparations. Just the last week, the Long Trouble facility was the subject of a multi-agency law enforcement sweep, and yet another correspondent down. During that sweep and lockdown, Mr. Combs was removed from his unit so officers could search his contents. He was not entitled to be present for the search. Officers ruffled through his personal notes and left them scattered, out of order, and disorganized. These notes included his work product and notes reflecting communications with defense counsel. The officers also seized Mr. Combs' pens, leaving him unable to take further notes while reviewing discovery or during counsel calls. As a result of this lockdown, defense counsel was delayed in meeting with Mr. Combs, losing time for trial preparation. Additionally, MDC does not permit counsel to provide Combs with even the basic materials necessary for trial preparation. We cannot equip him with notebooks, folders, or physical documents, for example. How is a defendant supposed to be competently defend himself or consult with counsel in a case of this magnitude without basic materials? The problem is further compounded by the fact that the laptop the laptop provided to the government nearly a month ago still has not been given to Mr. Combs, so he has no means at all to even take notes. Release is required by the Constitution. They say under the Fifth and Sixth Amendments, Combs is entitled to meaningfully participate in his defense and collaborate with counsel. So they're saying that his rights are not being upheld here. This is being violated. For the foregoing reasons and ensure a fair trial and protect Mr. Combs' constitutional rights, the court should order release on the proposed conditions or any other conditions the court deems appropriate. So they want to release him on these things. I pretty much read the whole thing. The last thing I didn't really go through. It has a lot of case law, and it's just basically saying that it's his constitutional right to be released under the Fifth and Sixth Amendments. That's what they're saying. So at this point, the government is going to respond to this. And then I'm not sure how many back and forths they're going to have before the judge finally makes a decision. I personally feel like the judge is going to say, nice try, bye-bye, go back to your cell. But with the knowledge of all of the different, I don't know, things going behind the scenes, I guess you could say, as far as like the government, the interagency sweep and all of that stuff, I kind of do feel like he still has some pull. Like something is going on, and it seems like, I don't know, it's a little weird. Hey, Ray, Shamina, Miss Sunshine, good to see y'all. Wow, Wayne, you made it. Ju T, what's going on? Sorry, y'all had to kind of rush through this. I will be back tonight with a live with more fun topics. But yeah, that live is already scheduled. So go ahead and hit the reminder on that and hit the like button and even throw a comment in there for me. So YouTube will open up the gate so people will actually know I'm live. I appreciate y'all so much. And let me know in the comments what you think about this. I see y'all commented. I'm going to read them through when I get through, but I do surely always and forever appreciate y'all.
Toodles. Toodaloo. Move around. Go on somewhere. Do you. You know, get on. Scat. Bye. Dip. Flee.